Hello, welcome to Coffee Talk with immigration attorney Brian D. Lerner. What is the subject for this week? Well, we're going to talk about preconceived intent. Um, that is a significant issue because so many people do it, and I get so many questions on it that I thought I would make a video to explain it in a little more detail. So, first of all, in order to get into what preconceived intent is, let's start with the B2 visitor visa. Okay, I'll do a typical scenario where people fall into the trap and they either end up getting the petition denied and or deported, and they have no idea why or what happened. So somebody comes in on a B2 visitor visa, okay, and they don't tell the officer anything other than they're coming to have fun, vacation, and then they come here, and then very shortly thereafter, they get married to a U.S. citizen. They then apply for adjustment of status, and at the adjustment interview, not only is their case denied, but they're issued an NTA, a notice to appear, and they are put into removal proceedings, and they are deported. So what happened? Why does this happen where from their point of view, they just came in and got married to a U.S. citizen that they are madly in love with? Why would they be deported, and why would the case be denied? Well, first of all, you have to understand what is a visitor visa used for and what are the laws requiring issuance of the B2 visitor visa. Well, first of all, it is what it says. It is meant to visit. It's temporary. You, the person coming in, have to have the intent to return to your home country. That is the first thing. That's called non-immigrant intent. So if you're coming from a country and you're coming to the US on a B2, you're going to go visit Disneyland, you're going to visit friends, you're going to travel, but ultimately you're going to go back to your home country and you are going to leave once the visitor stay here expires. Now, that is what is required, okay? And in fact, when coming on a B2 visitor visa, the law says that you are presumed to want to stay here forever. So you have to prove them different. You have to actually prove that don't intend to stay here forever and that you're going to leave. Now, when you come to the US and within 90 days, you do something that is inconsistent with the terms of the visa, then it can be denied. It is a presumption that you intended essentially to commit fraud, that you intended not to do what was the basis of the visa, but to do something else. So if you come into the United States on a B2 and you get married a month later, 2 months later, it is presumed you intended to do that when you entered the US. Okay, that is a rebuttable presumption, which means, you can submit all kinds of paperwork and documents showing that wasn't the case, but it is your burden to prove that. So the and it's not easy. So if you come into the US on a visitor visa and you get married 30 days later, all kinds of questions are going to be asked. When did you meet your spouse? How long have you known your spouse? When did you first talk about marriage? How long have you been deciding whether to get married? Did you intend to marry when you entered the US? Do you have a job back in your home country? Do you have property back in your home country? Did you sell it all before you came to the US? Do you have any assets in the home country? Do you have anything or anyone to prove that you really intended on going back? And then, if you decide to lie about when you met your spouse and so forth, they're going to go into the records. They're going to go, okay, well, what happened when you were here 6 months ago? Who did you see? Where did you go? They're going to question all into that. So it's not easy to win on a rebuttable presumption that you committed fraud. So If your intent is to outsmart immigration by coming into the US on a visitor visa and then turning right around to get married, you're not going to win. And it's a whole lot more work to try to get out of a deportation proceeding or removal proceeding to try to show you didn't commit fraud. The items that you will have to go through by trying to defeat and outsmart US immigration is not going to be worth it. If your real intent is to get married, then you just have to go the normal route. Your spouse has to do either a fiance visa petition, which yes, you're going to have to wait 9 months to a year to get that, or marry you in your home country and do a consular processing spouse visa, which that'll take about a year to a year and a half. I mean, I understand that you want to be with your spouse tomorrow. You don't want to be apart for that period of time, and you'll do anything in order to avoid that. But you're not looking at the bigger picture of what will happen when you're sitting across the table and the officer is looking at the dates of when you entered, when you got married. I mean, again, clearly, if it falls within the 90 days, you're going to have a very difficult time trying to win. So some people that know about this 90 days, they wait till the 91st day to get married. And while there is not a rebuttable presumption of fraud on the 91st day, the law specifically says that even after the 90 days, they have the right to deny based on what they perceive to be intent, which was incorrect at the time that you entered. So don't use the visitor visa as a way to get into the United States to get married. Okay, there's too many hurdles you're going to have to jump, and you will not be able to jump them in order to make it happen. So if you like the video, click like, subscribe. Hopefully you have a better understanding of preconceived intent, and more on the coming weeks. Thank you. Bye.